Okay, so good morning, everybody. It's 10 o'clock, and day 15 of the hearings here in Epping Forest is now open. Welcome, everybody. Can everybody hear me? Thank you. Okay, so my name is Louise Phillips, and I'm the inspector appointed to examine the Epping Forest District Local Plan, and the programme officer is Louise St John Howe. First, could I just ask if anyone with a mobile phone could switch it off or turn it to silent, please, and turn to the council for the fire procedure.
Thank you, Madam. There's no planned fire drill today, so if the fire alarm sounds, we do need to leave the building. The exit is the way you came in, down the stairs and assemble on the green to the rear of the civic offices. If for any reason that entrance is blocked, we can exit the alternative route, which is through the doors behind me, down the stairs and through the car park. The toilets are located on the stairwells as you came into the building.
Thank you very much. And I just need, as usual, to remind people of the filming procedures. So I need to remind you that this meeting will be broadcast live to the internet and be capable of subsequent repeated viewing, and copies can be made available upon request for anyone who asks to see it. By being present here today, the recording cameras are likely to capture your image, and your image will become part of the broadcast. This could infringe your human and data protection rights, and if you have any concerns about this, then please speak to the webcasting officer. Please also activate your microphones when speaking by pressing the button with the face on it. Thank you. So we're here today to discuss housing this morning, and it's my aim to be done with the housing session by lunchtime. And then after lunch, we are going to discuss Matter 9, District Open Land, and Matter 10, the natural environment, landscape character, and green and blue infrastructure. So could I just ask everybody around the table to introduce themselves, please, and say who you're representing and what your interest is in this morning's session. Thank you.
Good morning, Madam. I'm Mark Beard, Counsel for the Council. To my right sits Mr David Coleman, and to his right, Ms Alison Blom-Cooper, both from the Council. And this morning we're being assisted by Ms Nikki Linehan, Consultant to the Council.
In relation to Latton Priory.
Morning, Madam. My name's Councillor Peter Gooch. I'm Chairman, Thaden Boys Parish Council.
Good morning, Councillor Elizabeth Byrne, Thaden Boys Parish Council.
Good morning, Inspector John Goodall of DLP for Peer Group, Ongar Park Estate at Northfield Bassett.
Henry Stamp, individual resident of Epping, and just for clarification, I don't have any interest in housing, bungalows or otherwise, apart from the house I live in Epping.
I'm Mr Derek Stebbing from Stratton Park, representing Scott Properties.
I'm Ian Butcher from Andrew Martin Planning, representing Miller Homes.
Good morning, it's Paul Belton of Carter Jonas, representing Pigeon Investment Management.
Okay, so before turning to the issues that I covered in my matters, issues and questions, you'll see on the agenda that I just wanted to raise an additional matter, basically to hear people's views on it at this point, which the council made a request that I've hopefully, it wasn't on my copy, but hopefully printed out on the copies of the agenda so everybody can see them, was a request that the 5-year supply of deliverable housing sites with the appropriate buffer is fixed through the examination of the plan in accordance with paragraph 74 of the revised NPPF 2019. Now I'll ask the council to explain its request, and then I'll take comments upon it around the table, but I'd ask you to stick to the principle of that argument now. I don't want to hear about the 5-year supply, the council's actual 5-year supply in this session. Thank you. The council, please.
Thank you, Madam. So we did indeed write to you on 29th of April to request that as part of this examination you consider the 5-year supply of deliverable housing sites, and you confirm that to enable the appropriate buffer to be fixed in accordance with paragraph 74 of the 2019 NPPF. The Council considers that confirming a 5-year supply as part of this examination is is a pragmatic approach, would be a pragmatic approach, and will help to ensure and maintain a plan-led system once the plan is adopted. In doing so, it will provide greater certainty for both applicants and decision makers and help the council to ensure delivery of the plan. It will also allow the council to fix the 5-year land supply position on an annual basis through an annual position statement. And I understand that if this examination doesn't endorse or approve the 5-year land supply, then the council wouldn't be able to go through that annual position statement process. So we feel it's a pragmatic and would be a helpful approach to assist the council in the future and applicants.
Before I take any other comments around the table, are you able to say anything in the context of my examination of this plan being under the transitional arrangements in accordance with the 2012 framework?
Yes, certainly. So the transitional arrangements set out in paragraph 214 of the 2019 NPPF do apply to the examination of this plan. That's not in question at all. And so therefore the soundness of the plan is to be tested against the 2012 framework. As far as we're aware, the transitional arrangements do not provide a specific mechanism to allow the council to establish the 5-year land supply. However, because the council produced the plan and published the Regulation 19 version prior to the publication of the new NPPF, or the 2019 NPPF and 2018, we published it in December 2017. It didn't give us the opportunity to set out our intention at that point in time. So we weren't able to give notice of our intention through the examination process. And given that the examination process will test whether or not the council has a 5-year land supply on adoption anyway, it would seem pragmatic and expedient for you to consider and determine this issue at the same time. We're also confident, as you will have heard from earlier sessions, that we have undertaken substantial engagement and certainly sufficient engagement with the development industry and other stakeholders in terms of delivery assumptions and the work that we've done for our housing implementation strategy. And therefore we're confident in the robustness of the trajectory and of the 5-year housing supply, which is obviously fundamentally, the approach we're proposing is fundamentally linked, the step trajectory to the 5-year land supply itself. So it does need to be considered as one. We also consider that whilst it would have been obviously ideal to have made this intention clear at an earlier stage, it wasn't possible, but we don't think anyone will be prejudiced by this position or by the ability for you to consider this issue now, not least because obviously we're raising it today, and also others will be able to comment through in due course through any main modifications consultation that takes place. Thank you.
Thank you. Did anyone else want to speak to this point? No. Okay. Thank you. Mr. Roberts.
Thank you, Ma'am. Perhaps the council could clarify their thoughts on whether this is procedurally acceptable for a plan which is being considered under the 2012 framework, under the transitional arrangements. Is it possible then to apply the policy position derived from the current framework? I'm not clear that how that works for the purposes of how the plan's assessed, and whether it's possible for the council to, if you like, pick and choose bits of the respective frameworks that it might wish to apply in different instances, quite apart of whether it's pragmatic to do so or otherwise. I would also wonder if it's sort of in terms of how, in the practicalities of this, if the plan were being considered under the 2019 framework and the supply position were to be set in accordance with paragraph 214, would it not be reasonable to assume that the council would have had to, if you like, further scrutinise its supply and demonstrate to you the robustness to a greater degree than perhaps would be the case for a plan considered in the 2012 framework, in that the provisions of that framework assume that 5-year supply would be tested more frequently in different ways throughout the plan progresses. So I would question as to whether it's correct procedurally and practically for the council to take this approach.
Thank you. Largely to echo the points that have just been made, but I think pick and choose is probably the correct terminology. Paragraph 3, we don't consider that this option is open to the council, precisely because updated planning practice guidance, which clearly applies in the context of this discussion and takes us beyond the transitional provisions that this plan is being examined under. But paragraph 349 very clearly says that any request should be set out and informed to stakeholders notified at the Regulation 19 stage. And I think that's really important because that sets the context for the examination, not least the weight that's given to the emerging policies and the position of objectors. And I think that would change the whole process for how the examination was run, not just in terms of the council's updated position in which they claim to have taken account of the revised definition of deliverable supply. And I note that the housing implementation strategy was updated in January 2019, but the definition has actually since been revised in the February 2019 version. But it's already been shown at the examination the substantial volume of objections that stem not just from emission sites, but also the promoters of sites included in the plan. Because if you're in a situation where you're picking and choosing bits of the NPPF and elements of the revised NPPF that will apply for DM purposes in terms of housing mix, affordable housing tenure, each of those objectives should be brought back to the table in a thorough and comprehensive discussion rather than what seems to have happened, which is more selective engagement, not in the context of the examination following the Regulation 19 stage. So it isn't appropriate to pick and choose those elements of the position and consider that this will have tested and is capable of confirming a 5-year supply in the position we're in now. And I think to do so is quite dangerous in terms of case law on housing land supply, things like the Wincanton case, where the government's updated the NPPF because it set out robust guidance for following the annual position statement that will stop you picking and choosing not just your approach to national policy, but also the people you engage with and the conclusions you come to on deliverable supply. And so for that reason as well, the whole process should be followed, and it's not possible to follow it by making the request at this stage in the process.
Thank you.
Mr. Stebbing.
Thank you, Madam. I don't have any objection in principle to the request, but it is regrettable that the request has come on May the 22nd, albeit that you received it a month or so ago, because it does reopen, in my view, matters that you considered under Matter 6. And particularly issue 2 that day. And you may recall that I pointed you to what I accept is an unintended error in the trajectory there regarding the buffer, or the application of the buffer. I haven't yet seen any revised data that removes that error. And personally, I think this additional request today actually requires you to revisit some of the material you looked at under Matter 6.
Thank you. Okay, last points from the council to come back on anything that was raised there, and we'll move on.
If I may, very, very quickly, the very important point to make here, and this answers, I'm afraid to say, Mr. Goodall's point completely, is that the facility within current national policy and practice guidance that enables a council to request that a inspector appointed to independently examine a plan to establish the 5-year housing land supplies at the same time as examining the plan is to facilitate the process that is provided for in the PPG by which local planning authorities can thereafter, through annual position statements, set their 5-year housing land supply for a period of 12 months. It is a procedural aspect to policy. To be very, very clear, whether or not this plan is being examined against the 2012 framework or the 29 framework for the purposes of soundness has nothing to do with whether or not the inspector agrees, or whether or not a local planning authority or the inspector agrees to establish the 5-year housing land supply for a period of 12 months through this process. So in other words, it's an adjunct to the independent examination. Of course, the examination or the scrutinization of the 5-year housing land supply position serves two purposes. But requesting this process has nothing to do with soundness. If you're content that it's appropriate to scrutinise and the 5-year housing land supply is put forward on behalf of the council, and that those who are interested in that process have had a proper opportunity to participate, then there can be no prejudice. Insofar as the request has come late, any person, even if we had made a request at the Regulation 19 stage, given that we are substituting our trajectory in any event, any person who is interested in having something to say about our substituted trajectory will be given the same opportunity through the main modifications consultation procedure. But it cannot be right, given the transitional arrangements are intended to allow plans that have been prepared at an advanced stage to be examined fairly without having to go back to the beginning through the examination process, the soundness as against 2012. It cannot be right that those planning authorities, and therefore the public interest, is denied the opportunity for a period of 5 years to bring forward annual position statements to avoid the circumstances of having to prove a 5-year housing land supply every time we make a decision or at every planning appeal. So it's a pragmatic approach, there's no doubt about that, but it's a fair approach as well. And any questions of picking and choosing, I'm afraid to say, just miss the point. The reality of this situation is that we are requesting and have raised this issue with the Ministry of Housing and Local Communities and Local Government, who accept that in short form, accept that we shouldn't, that planning authorities in our position shouldn't be in any way prejudiced just because we brought our plans forward through an advanced plan forward through the examination process in the way that we have. If, Madam, you are concerned about the fact that some may have had something to say more than they did say at an earlier stage of this examination, then the opportunity for those persons to bring that to your attention will be through the consultation process on the main modifications. And at that time, if you consider that it would not be appropriate to establish the 5-year housing land supply as we put it as part of this process, then there can be a further hearing. And in my respectful submission, that would answer all of the points that have been made this morning.
Just finally on this, Mr. Beard, did you say that you'd had some advice from government?
I
I haven't seen that.
We've had an exchange of correspondence with the ministry, which would certainly be willing. Ms. Blomcaper,
We've had a meeting with the Ministry of Housing and Local Government around the housing delivery test arrangements, and this matter was raised with them then, and they've replied to us with a pragmatic approach and saying that effectively the 5-year supply should be fixed through the local plan process.
I think it would be helpful to see that.
Yeah, I mean, it contains other matters which are confidential to the council, so I wouldn't want to share. Want to share the whole email.
Fair enough. Thank you. Thank you. We'll leave that. We'll leave this matter here for now. It's something I'll give some thought to. If we can move on to. Am I right? Piece of paper? Okay, so if we can move on now to issue 1 concerning policy H1, and will this be effective in securing an appropriate mix of housing? Now, you may have seen the council has produced a track changes version of the policy, which includes the amendments that I think you have seen through the statement. First point to consider is dwelling mix. Now, from the statements I read, I got the general impression that people support the flexibility offered by Part A in its not prescribing a specific mix of housing. And so the council has proposed a modification to paragraph 3.3 to signpost the Office of National Statistics as a source of information concerning the housing and population profile of the district. And so my question is, would this, along with the other information provided in the supporting text, enable developers to respond to Part A? Now, perhaps it would be useful to hear if anybody has any concerns about that before we ask the council. And just to point out, if you do have anything to say on any particular point, if you'd put your board up as soon as possible, then I know whether people want to say anything or not. Thank you. So, Mr. Butcher.
Thank you. Basically, our concern really relates more to the community-led planning aspect of the policy. I understand from matter 8 on the garden communities in relation to policy SP4 that there's a potential for a definition of community-led planning to be included in the glossary. I just want to ask whether that has been considered or if that will be included. And then further to that, asking what sources of information developers should use or look at to identify the appetite locally for community-led planning, and whether that source should be included within the modification as another source of information for that.
Thank you. Thank you. Could I ask the council to explain that provision of the policy and to respond to Mr. Butcher's comments?
Thank you, Madam. We consider that signposting the ONS as a source of information is appropriate. The ONS data provides a robust and clear starting point in order to understand the context for development of an appropriate mix of housing on individual sites. The ONS data also provides information which is local to individual sites, as it provides data at a sub-settlement level. This, coupled with other information provided in the supporting text of the policy, does give a clear starting point for development proposals so that they can respond to policy H1. In particular, it supports the objective of achieving mixed and balanced communities within a more local context, as set out in policy H1, part A, little 3, and paragraph 3.3 of the plan. So as you've rightly said, the modification to 3.3 is set out on the sheet provided and in the hearing statement. In terms of Mr. Butcher's comments, I think we haven't yet produced a definition for community-led housing, and we certainly take on board his suggestions and comments. I think it would be helpful to signpost towards information for understanding needs for community-led housing as far as possible. That's something we can obviously take away and add in as required. I don't think there's anything further to add on that.
Thank you. Thank you. If you could do that, I think that would be helpful. Thank you. Okay, moving on then to older persons housing. Again, I think perhaps if I just ask the council to just explain the modifications to this policy, or just to confirm that I've recorded them correctly. So these are the bottom bullet points on my agenda. So in relation to Part E, an amendment is proposed to paragraph 3.6 into the glossary to define specialist accommodation. And also to clarify the management arrangements for specialist accommodation. Also proposing to amend Part C and paragraph 3.2 concerning the provision of specialist housing and the duty under Section 8 of the Housing Act. Do you want to just explain those, Mr. Coleman?
Yes, certainly. Would you like me to just briefly deal with the points you've raised under older persons housing at the same time as explaining the amendments?
You can do, yeah.
Yeah. So in terms of the need for specialist accommodation for older people and whether or not that's been identified, yes, a specific need for specialist accommodation has been identified, and Council considers that the approach to the plan, to meet the need is appropriate and justified. The SHMAR, the latest, or the main SHMAR, which is 2015, document reference EB 405, provides an indication of the projected increase of the institutional population over the plan period. It does that for the whole housing market area, which obviously includes East Herts, Harlow and Uttlesford, as well as Epping. And it identifies a need for 1,773 persons. It does not break this figure down by local authority area, nor does it indicate the number of units required or floor space required. But taking the figure as a whole, 1,773 persons, if you divide that by the 4 districts, it equates to approximately 443 persons per district, which would equate to approximately the need to accommodate 20 persons per annum. The local plan addresses that need through a number of different policies, which are essentially Policy SP3, Policy H1 and Policy H2. Since the start of the plan period in 2011, the Council has granted planning permission for a total of 238 additional units, plus 12 bed spaces on 7 different sites across the district. So that averages approximately 35 units per annum. That doesn't include the specific provision in the plan made through site CHIG R5, which, as you recall, that allocates, the site is allocated for 105 C2 units. So, in other words, the needs coming, the supply coming through is clearly sufficient to meet the overall need for the number of persons highlighted in the SHMAR. The Council doesn't think there is a need, therefore, to make any additional specific allocated provision for specialist accommodation for older people, and we consider the range of sites proposed to be allocated and provides sufficient opportunity without being constrained by the environmental factors. In terms of whether or not the plan ensures specialist accommodation provided for older people will be available in a range of 10 years, the plan will ensure that older people will be available, that accommodation will be available in a range of 10 years. One of the objectives in the plan is to ensure new homes provide an appropriate mix of size, types, forms and tenures, etc. to meet local needs. This objective is reflected throughout various parts of the plan, but we do feel that policy H1 Part A could be further strengthened as indicated on the sheet. So by adding the word to Part A, little 1, specifically adding the word tenure, and at the end of the sentence by adding and specialist housing as appropriate, just to make it very clear that that's part of that. In relation to Part E and the proposed amendment to paragraph 3.6 and to the glossary to define specialist accommodation, Council considers that the amendments to paragraph 3.6 and to the glossary and the clarification regarding management arrangements are justified. Again, they're set out on the sheet and set out clearly in terms of what's being proposed. The modification to Part C and paragraph 3.2 concerning the provision of specialist accommodation and the duty under Section 8 of the Housing Act. The proposal to modify Part C of Policy H1 follows discussions at the hearing session on Matter 3, Issue 2, and that reflects the Council's duty to identify the needs for some types of homes under Section 8 of the Housing Act 1985 and to provide sufficient clarity. So there are amendments both to the supporting text.
What exactly are you changing in Part C? It just looks like you've put a bullet point list instead of a ordinary list. Just make sure that it's accurately...
Yeah, that's one of the primary changes, to make it clearer, but also to change meet. So little 1 is they meet an identified need rather than a proven identified need.
Okay, yeah.
That's that reflected. Yeah, so that's reflected in the sheet. And then the supporting text, paragraph 3.2, specifies the role of the council in more detail.
Thank you.
May I just add something? You may recall, Madam, that this policy, we raised this policy, did we not, in the context of traveller site caravans. Let me start again. In the context of policy H4 earlier in the examination, where it was considered, where we spoke to the difference between traveller site development and housing accommodation in caravans by persons who were travellers but do not fit the definition, do not meet the definition in the planning policy for traveller site national policy. The idea of removing the proven identified need here was to ensure that there was no suggestion, or it could not be misunderstood as there being a discriminatory approach that required persons who resort to living in caravans or mobile homes who are travellers within the non-planning definition in the word gypsies, Roma or travellers. Wider definition could be said to be being prejudiced or discriminated against by having to demonstrate that they had a need or that a need existed for the accommodation. That's the responsibility and ought to be the responsibility for the local planning authority to demonstrate in all circumstances.
Thank you. Thank you. Mr. Roberts.
Thank you, ma'am. Just a brief comment regards the proposed modifications to paragraph 3.6 in the supporting text. The management of any specialist accommodation will be proposed will be required to be undertaken by a provider registered with the Care Quality Commission or any subsequent national registration authority, and the proposed provider should be identified as part of any planning application. I would wonder whether the management of say, a C2 use or a facility such like that is it necessary as part of the planning application to understand the detail of how it's going to be managed, who's going to manage the property? My question is to whether that's appropriate at that kind of early stage. I'd also wonder in practical terms how that would work. Say, for example, if you submitted an application for outline planning permission, you wouldn't really know, you wouldn't necessarily know from a developer's perspective who the end user is going to be. It's likely that they would be registered by the Care Quality Commission, and it's perhaps likely that you'd know who they were, but you couldn't necessarily guarantee that. And I'd also think that, say, for a conventional planning application for a conventional C3 residential dwelling, that would be blind, most likely, to, or could be blind to the house builder involved. So why is it necessary for the purpose of a specialist accommodation to identify the end user?
Thank you, Mr. Goodall.
Thank you. I think I would start by saying that the changes to Part C of Policy H1 we'd broadly agree with, and also pick up the point on community-led housing earlier as well, as being relevant in that list of definitions. The reason that's relevant is because upon adoption, particularly for those preparing neighbourhood plans, for example, paragraph 61 of the 29 framework will come into play, and assessing those specific needs and positively determining any proposals that seek to meet those will become relevant. And so the concern I think we've got regarding the policy for specialist housing is that it doesn't really fully reflect the evidence base and the flexibility needed to provide for those needs. So paragraph 6.18 to 6.24 of the SHLA say that there's an expectation that fewer older people reside in institutions and that the needs of the older population should be assessed against and included in the OAN. Now, that's not been undertaken by the council, but clearly there will be a relationship for general needs sites potentially meeting the needs of older people who wish to stay in general market housing. And in some ways that goes back to the issue we'd also have with the council's change to H1 and the reference to the ONS data for housing mix, because that will lock in past trends, whereas in a way you should be planning positively to meet the needs of older people, both within specialist products and general needs housing. And so that takes me on to paragraph 6 of the council's response to its question 2 statement, where it says the approach to allocating sites in the local plan has considered accessibility or potential accessibility and access to passenger transport services. Again, that goes hand in hand with what I'm saying. There will be a role in general needs sites meeting those needs. But in a way, if you're planning for a mix that locks in past trends, and we would argue that sites haven't been assessed to note those criteria and the opportunities available, then the plan's doing neither nor. It's not successfully meeting the needs for specialist housing, and it's not addressing the guidance in national policy and also its own evidence that addresses the relationship between the needs of older people and remaining in market housing. Generally, again, we would say that's a lack of flexibility. That stems from a lack of flexibility in the plan. The plan won't be flexible enough to address those specific needs that will be identified going forward under the 29 framework, and that things like neighbourhood plans will, or the evidence base for neighbourhood plans will highlight. So I think while the modifications to H1 are appropriate, it doesn't mean that the most appropriate strategy has actually been selected to meet those needs going forward.
Mr. Stebbing.
Thank you, Madam. I only partly agree with Mr. Goodall's comments. Frankly, the proposed modifications to Policy H1 Part C are, in my view, purely cosmetic, and I could liken them to rearranging the deck chairs on the Titanic. The plan simply does not address the demographic projections for the district, or indeed at a local level. Now, our hearing statement has provided you with detailed projections for both the district as a whole and the Chigwell area, whereas you know we're seeking the allocation of a site. The plan underplays the demographic impacts of the ageing population in Epping Forest, and particularly those that may need very specialist care such as dementia care. Simply pointing users of the plan to the ONS is in part masking the problem. The plan itself should be identifying in much more detail the demographic projections for this district. It's not just an Epping Forest issue either. It's actually a wider issue nationally. You will have seen, I hope, Madam, one of the appendices that we attach, where I pointed you to a more positive approach being adopted in the Chelmsford local plan that's presently at examination. Gives you an indication exactly what is required for specialist residential accommodation in Chelmsford district. 60 units per annum to be precise there. I do not see why this plan cannot go that extra step. It should be a separate policy, actually. It shouldn't be embedded within policy H1 in this way.
Can I ask you what you say in response to what we heard from Mr. Coleman about the findings of the SHMA and the provision that has been made and is proposed to be made through the plan?
I think the SHMA is actually out of date on this point. It's a 2015 document, fundamentally, albeit updated. The work that I presented you by Experian does point to a higher need. Now, I accept there's a difference between the two sets of statistics, but clearly I'm relying on the Experian data. And that prepared as part of a planning application by Carterwood. You have the documents, as do indeed the council. The provision that Mr. Coleman points to having been made or permitted here in Epping Forest, I think is simply just scratching the surface.
Thank you. Come back to the council on those points raised by Mr. Roberts, Mr. Goodall and Mr. Stebbing.
Thank you, Madam. If I start with the point around management arrangements raised by Mr. Roberts, the management of specialist housing, I'd point you towards paragraph 17 of our Matter 11 hearing statement, which explains further the rationale for the modification and the purpose of it. The reason for specifying that management of affordable housing, specialist housing, needs to be undertaken by a registered provider, recognising that providers of specialist accommodation are regulated. So it's to do with the regulation arrangements. So firstly, the Care Act 2015, whereby councils must ensure that there are a range of providers offering a choice of quality care services and that care and support functions are integrated with those provided by the NHS and any other health-related services. And also, secondly, the Health and Social Care Act 2008 and regulations in 2009, as well as the Care Quality Commission regulations 2009, whereby care providers are required to register with the Care Quality Commission. The Commission regulates care provided by the health authorities, local authorities, private companies and voluntary organisations. So the amendments provide clarity and consistency across the plan in terms of the approach that's taken for specialist housing and affordable housing, as well as ensuring that the council is following the relevant regulations and legislation. In terms of... Sorry,
before you move on, just in relation to Mr. Roberts' point around the sort of practicalities of that, is it necessary for the sort of last part of that sentence to be added? So the management of any specialist accommodation proposed will be required to be undertaken by a provider registered with the Care Quality Commission or any subsequent national registration authority, full stop. Omitting the final part of that sentence, because if you think it's appropriate to retain that, then perhaps if you could sort of specifically address the point that he raised about how, you know, for example, at the planning application stage, you might not be able to actually identify the end user. I wonder whether that part of the sentence is necessary, or whether if you sort of stopped it to where I stopped reading, it would still provide the ability for it to be secured through the planning application process, but at the appropriate point.
Yeah, I think we understand the practical difficulties there. It may be that rather than taking it out the end of the sentence altogether, it needs to say that where possible it should be agreed as part of a planning application, but understanding that that won't always be possible. Equally, it potentially could be removed. I think perhaps if we can take that away and
perhaps if you think about how the objective might be achieved, rather than, because I take his point on perhaps an outline application.
Yeah.
It might be difficult to identify the precise provider, even though the sort of principle of what type of provider it must be could be secured or something like that. If you just think about the wording.
Yeah,
Thank you.
absolutely. Yeah.
Thank you. Sorry, if you want to go on to
No,
Mr.
that's okay.
Goodall or Mr.
Yeah,
Stebbings' points.
In terms of Mr. Goodall's points, I think we probably would disagree in terms of the way the evidence is being used. I think the evidence is there to indicate the needs of older people, and I set those out previously and in our matter statement, and they are identified in the Strategic Housing Market Assessment. I think it's appropriate to use that evidence to understand the types of needs that need to be planned for, and as I highlighted, I think the needs can be addressed through the policy approach that's being pursued by the council. I also dispute the fact that the plan is not flexible enough. I think the plan is flexible and will allow for different needs to be met in different forms in the future, including any needs identified by neighbourhood plans. It's worth, I think, also highlighting paragraph 6.22 from the SHMA. Again, that's EB 405, which highlights the changing nature of needs and provision. Suggests that specialist housing for older people offered today may not be appropriate in future years. And the government's reform of the health and adult social care is underpinned by a principle of sustaining people at home for as long as possible. Consequently, whilst the population in the district is projected to include a higher proportion of older people over the planned period, future policies may lead to a decline in the number of care homes and nursing homes, as people are supported to continue living in their own homes for longer. So as I indicated earlier, I think the council does consider that the plan does not need to make any additional specific allocated provision for specialist accommodation for older people, and actually the plan is flexible enough to respond to those changing requirements. Also, the fact that there is a significant amount of strategic planned growth, if you like, on large sites means that there are significant opportunities to respond to the policy requirements and to provide different types and different tenures of homes and accommodation to meet the specialist needs of the population and of older people. Policy SP3, which is the place shaping policy, makes very clear that strategic master plans and development proposals should provide mixed tenure homes and a range of housing types and sizes. In terms of Mr. Stebbings' points, again, I think similar points. I would take a similar response to those points raised. The needs identified in the Strategic Housing Market Assessment are robust and are being used across the housing market area for plan making, and we think provide an appropriate basis. And as I've explained, we think there's sufficient flexibility within the policies to meet the needs arising and to meet the changing needs over time.
Thank you for that. We'll move on now to the optional technical standard M42. Now, for clarity, I think this provision relates to Part A5. So the requirement that development would be permitted where the mix of new homes provides for all new homes to be accessible and adaptable as defined by the building regulations in effect at the time of the application. Now, so my overall question here, as on the agenda, is it justified to require all new homes to meet optional technical standard M42? The Council has confirmed that that's its intention for accessibility and adaptability. And if it is justified, should this requirement be clearly set out in the policy? So I think, first of all, I could ask the Council to explain the evidence that justifies this requirement for all dwellings, perhaps looking for local evidence, rather than just a sort of a national picture. And just confirm, I think it's the intention is you're not requiring the M43 wheelchair accessible dwellings. Is that right? Yeah. Okay. Thank you.
Thank you, Madam. Council considers the requirements for new homes to meet the optional technical standard M42 for accessibility and adaptability is justified, and that's set out, the reason for that set out in paragraphs 9 to 12 of our hearing statement in relation to matter 11, issue 1. In addition, the requirement also takes into consideration the following. Paragraph 6.22 of the SHMA, it's EB 405, that's on page 106, which concludes that specialist housing offered today may not be appropriate in future years, and the government's reform of health and adult social care is underpinned by a principle of sustaining people at home for as long as possible. Additionally, that the existing housing stock of the district does not provide such opportunities. So the requirement would provide an opportunity to make a material contribution to rebalancing the accessibility of the overall housing stock of the district. It would also ensure that such opportunities are available across all parts of the district and to all types and sizes of homes. This would provide greater opportunity.
Sorry to interrupt, Mr. Coleman.
Sure.
Were you saying that that paragraph of the SHMA says that the existing stock doesn't provide that opportunity?
No,
or is that
apologies.
something?
No, that's the second point.
Okay.
Sorry, the SHMA reference was
No,
in
no,
terms
yeah,
of,
that's fine.
yeah.
So your point is that the existing stock doesn't
provide
provide
those
for that opportunity. Do you have any? Have you looked at the nature of the existing stock? Do you have anything sort of underpinning that statement?
We don't have any specific numbers. I think it's more a case of the fact that there hasn't been substantial development in the district for some time and the standards haven't been in place. So clearly they haven't been applied and they haven't been provided. So we think it would provide a greater opportunity for those with mobility impairments in the future to have choice, redressing some of the imbalance in the stock and ensuring fairness and equality for all. Council proposes an amendment to the final sentence of paragraph 3.4 in the supporting text. And that provides further clarity on the requirement. Thank you.
Any comments? Mr. Belton.
Thank you, Mark. As you will have noted from our hearing statement, we've made the case that we consider that complying with M41 the mandatory targets is sufficient to provide adequate levels of accessibility. If, based on local evidence, there is a view that a requirement for M42 is justified, I think we would probably agree more with the wording at the beginning of paragraph 3.4, which talks about a proportion of new homes being provided, rather than all homes, which is what's coming out through the modifications being presented today. The inclusion of text allowing a viability statement is something we welcome. We've seen these policies come forward in other local plan areas, and they have caused issues in terms of their deliverability, because there are significant implications of complying with M42. So our fundamental point is we don't think it's necessary, but if it is, then we think it should be a proportion rather than all.
Sorry, Mr. Belton, you mentioned that it presents significant difficulties. Can you just give us a flavour of what those difficulties are?
Yeah, I mean, it has become an increasing issue in Cambridge City Council, where this similar policy has been adopted recently, and particularly in the form of providing apartment buildings over two floors or more. The requirement to install lifts has significant viability implications. The policy at Cambridge isn't as flexible as what's been now proposed through the modifications, and officers have had to sort of slightly backtrack and introduce a viability checklist through supplementary advice to applicants. But that's the key concern, really. It's the cost of the infrastructure needed, particularly when it's in apartment buildings.
Thank you. Mr. Butcher.
Thank you. Yeah, I think while we accept, the growing trends and the need for a greater sort of accessible housing, I think our sort of point is that essentially it's a big leap to go to apply it to all future housing, and that we sort of consider it should be a proportion. I think you picked up on the point. We would like to see a more sort of local analysis, perhaps one based on need or demand, and we've suggested, based on sort of the SHMAR data, that a 36% proportion would be a sort of more suitable percentage.
Why 36%?
That's based on the proportion of population growth in those aged over 85 projected in the SHMAR.
Can the council offer anything more about what can be achieved with the M42 standard in terms of accessibility than can be achieved through the mandatory standard? I guess what I want here is some sort of my recollection when you sort of read all of the guidance on this is that it shouldn't be a case of this is just something that's nice to have. It should be needed, because the mandatory targets, the mandatory standards should provide adequate accessibility unless there's a specific need for something more. And I guess I'm just looking for, is this something that's just nice to have? You've demonstrated that it's viable, or do you need this for a specific purpose?
Sorry. Thank you, Madam. I think it comes back to the point that whilst I appreciate the comment about the growth in the population over the age of 85, actually the ageing population in the district over the age of 65 is significant over the plan period. And what this does is to provide that equitable and fair choice in terms of location and type of homes that people are able to move into. What it also does is actually give developers certainty in terms of what is required in terms of their design of properties. And I think it's also important, as set out in the Housing Background Paper of 2016, that it's not just for older people. There is also a growth in mobility issues for people of all ages. And so it's providing that equitable and fair provision whilst providing certainty. It means that all locations of development where development is being proposed, people will have that opportunity to secure that, for want of a better word, facility. I think going back to the additional point around the difficulty with some types of developments, you notice in terms of the main mods para 3.4, that actually is recognising that for some types of development, particularly if lifts are required, that could be problematical. So the council is actually recognising and reflecting that in terms of the proposed modification.
And again, just going back to the practical question, what does it enable, what does applying that standard in practical on-the-ground terms allow you to achieve in terms of adaptability and accessibility that applying the mandatory standard doesn't? I mean, if it's absolutely necessary for all homes, why isn't it a mandatory standard?
That's probably a matter for government in terms of why it hasn't been mandatory thus far. The reality is that a lot of authorities are having to take this approach to be able to support the government's objective and also local objectives of keeping people in their homes for longer in terms of independence. What it does is it means that internal alterations, for example, in terms of width of doors and corridors, and be able to get round a property with a wheelchair or with mobility aids, you don't have to go and do structural alterations. So it's built in right from the word go. And that's the rationale in terms of why it goes beyond and why we're seeking that, because of the needs that are projected in the future for the district, coupled with that adult social care policy change at the national level.
And has the council taken account of the applying this standard in looking at the capacity and densities that you can get on development sites?
I believe we have, but we'd need to confirm that back to you, Madam.
Thank you. Sorry, one last point. One last point on this. If I conclude that it's justified, do you think the wording, as it is in the policy, is actually sufficient to deliver it? Because I appreciate that it's explained in the text, but just reading to be accessible and adaptable as defined by the building regulations, so how would you know whether you're applying M41 or M42? It doesn't actually say what standard you're requiring in the policy at all.
Yeah, I think we acknowledge that, and I think we can certainly look to revise the wording to make it clearer for little 5, and also to consider whether or not that viability clause needs to be in policy as well as in the supporting text.
Thank you. Okay, self-build and custom house building. Okay, so again, my reading of the council's statements, the council has indicated it would not be appropriate at present for the plan to set out how many self-build plots or homes it aims to deliver. So my question is, why? Why is that? And how will the plan provide opportunities for this type of development in practice? Thank you.
Thank you, Madam. Your reading is correct. The council's justification for not setting out how many self-build plots or homes it aims to deliver is set out in paragraphs 19 to 21 on pages 9 to 10 of the hearing statement in relation to matter 11. Council considers that opportunities for this type of development will be secured through policies in the plan, in particular through policy SP4 Part C, little 3, whereby the design, development and phased delivery of each garden town community must accord with a number of principles, including the inclusion of opportunities for community-led housing development. Such an approach will ensure that plots are serviced, which is an important consideration in securing such opportunities. Thank you.
Mr. Stamp.
Yes, I didn't object to this policy particularly, but it has an implication for what we're going to go and discuss about bungalows later on. You have seen from the statement, for reasons I won't bore you with, I have actually monitored over the last 3 years Plot Search and Plot Finder websites, which self-builders and custom builders frequently use to find plots. They are the two nationally recognised ones. And while certainly not the majority, there are a significant minority of plots arising which tend to be small, dilapidated, often bungalows, sometimes on larger plots, which self-builders, by definition, they're advertised, find attractive to develop into custom-built homes. And just to point out, I can understand there might be new provision amongst the large allocations, but there is an implication, and I can say it now to avoid me saying it later, with the bungalows policy, of that going against custom building of houses. So basically that policy, if it did more than resist, if it refused redevelopment of bungalows, which might be unsuitable, that is going to make an impact on the supply of plots for self-builders.
Thank you, Mr. Stamp. Anybody else? No. Could you address Mr. Stamp's concerns?
Yes, Madam. I mean, in short, the Council does not think that the approach to bungalows will reduce this, materially reduce the supply of plots available for self-build. Would you like me to go on and talk about the issue of bungalows at the same time? We consider that the intention of Part F to resist the loss of bungalows and specialist accommodation is justified and effective. Bungalows form a part of the supply of accommodation that can support independent living for people of all ages, including those with mobility impairments. The Council's Authority Monitoring Report from 2014 and 15, which is EB 1708K, on page 42, sets out that over the 10-year period from 2005 to 2015, there was a net loss of 10 bungalows across the district. Part F of Policy H1 seeks to resist the loss of bungalows. This does not preclude the redevelopment of existing bungalow sites, but rather ensures that any scheme makes re-provision within it for the same number of bungalows as is proposed to be replaced. Hence, the policy is worded, the loss of bungalows will be resisted, rather than existing bungalows must be retained. Nor does Part F of Policy H1 preclude the demolition of one bungalow and the provision of 2 or more bungalows on the same site. So in conclusion, we feel that bungalows do form an important part of the overall housing mix in the district, linked to some of the discussion we've had this morning, providing for the needs of the population. And we do not think that this policy approach will unnecessarily hinder self-build, custom build within the district. We think that the other aspects of the plan will provide other opportunities to meet those needs.
Thank you. And I have nothing to base this on at all, but is my perception perhaps of the fact that bungalows aren't commonly built now correct?
Yeah, that's correct.
Okay.
Yeah.
Thank you. I know Thaden Boys wanted to say something. Mr. Gooch.
Thank you, Madam. We would just like to say that we support this policy. In fact, we've seen this effectively used very recently in district planning committee meetings. We think it's very important to stop the erosion of the existing housing stock. Bungalows still play an important to provide that balance. We have a particular issue, in the village of Thaden Boys, where the bungalows have been eroded, and we do have a large number now of family homes being lived in by one person of pensionable age. And that's because they want to live in a bungalow, they don't want to live in a flat, but they want to stay in the village. So it's causing an unbalance. Thank you.
Thank you. Mr. Stamp.
Thank you. Two things. Thank you for the clarification from Mr. Coleman. I think in that case, probably F ought to say something like the net loss of bungalows. I think the wording at the moment doesn't imply what he said about redeveloping 1 for 1 or 1 for 2. And this word resisted I still have problems with in terms of plans are meant to say what's going to be permitted and what's going to be refused. And resisted isn't clear on that scale, and my statement said that kind of situation. Also, he said that's one thing, just I think it could be better worded for that. I still think there is a point, and I hear what Thaden Boys say, and I'm aware of the problem. And obviously, since I wrote my statement, I've thought of a number of other buildings I know of, bungalows, etc. Mr. Coleman said about wheelchair housing, about it gives the opportunity to rebalance the existing stock. Ms. Linehan said about avoiding the need for structural alterations. I mean, 3.4 is setting out to provide new homes which can provide for accessibility needs of people through the design of those homes. But 3.5 says it's going to try and meet accessibility needs, including for older people, which can be met by bungalows and their potential alleged ease of adaptation. And I think the problem is that people assume because bungalows don't have stairs, they are easy for older people and easy to adapt. And I have been thinking of a number of cases where that is not the case. There's space problems, particularly for wheelchairs. That space within the dwelling for moving around if you're going to have other furniture for the rest of the inhabitants if it's a family. Transfer space in toilets and bathrooms. Doorway widths which would need to be widened often, particularly 30s bungalows and ground floor accommodation to meet the needs of wheelchair users. That's not just widening the doorway, it might be moving electrics around, you've got a light switch next door to it. Bungalows, by their type, tend to have more corridors than houses, and those corridors, in the ones I can think of, are narrow, and therefore not good for a wheelchair user. So for all those reasons, I don't think adaptation of bungalows to meet particularly wheelchair users rather than just ambulant elderly people is nearly as good a way as providing new accommodation. And I don't see why for wheelchair accommodation, etc., it's being provided in new developments. And the needs of older people, as well as flats with private garden space, which I referred to, would be far better met in new developments, where the space standards, they can be age-proofed. I mean, there's the House of Commons CLG committee, early 2018, said more new bungalows should be built, and they should be age-proofed. And I think that's entirely the case for the population and the elderly population, rather than relying on sometimes old, cramped bungalows built to poor standards, not the latest environmental standards, sustainability, energy generation, which older people will appreciate a new build to good standards, because as they get older, they tend to be less inclined to want to do maintenance and things. There's obviously the best use of urban land and non-greenbelt land issue. And I think really for all that, new provision for elderly people in bungalows, new built bungalows, would have so many advantages. Whereas at the moment, I think the council are relying on presumptions about the adaptability of old buildings, which, in my experience, are not correct.
Thank you, Mr Stamp. We'll ask the councillor specifically about your point about the flexibility to perhaps redevelop bungalows. Couple of quick points on this bungalow matter now, please, if you keep it fairly brief. Mr Goodall.
Thank you. Largely echoing Mr Stamp, but specifically the entire clause should be deleted in a plan that, as we've argued throughout, is not positively prepared and hasn't sought to meet full housing needs. The clause also refers to resisting the loss of specialist housing. That's contrary to Mr Coleman's points on paragraph 6.2.2 of the SHMAR, in that some specialist accommodation will be unfit for purpose and people will try and stay in their own homes. If the council's arguments are correct on a requirement for part M42, whether that's all dwellings or a substantial proportion of dwellings, new development flexibly provided will meet those requirements. The council's plan isn't supported by a clear strategy for specialist accommodation or older persons housing in general. It's therefore totally inappropriate and not positively prepared to have the bungalows and specialist accommodation resistance that we're discussing without a clear strategy for either of the alternatives, either flexibly providing additional general needs housing with all the benefits that new development provides that we're discussing, or appropriate opportunities for redevelopment of existing sites. I think I'll leave it there, but it's totally contrary to points we've made in our representations on growths of other households that will need to be met in things like multi-occupancy housing, where you're not meeting full needs through the plan. And these additional restrictions are not appropriate in that context.
Thank you. Okay, Councillor Byrne, Councillor Gooch.
I just wanted to very briefly make the point in response to Mr Stamp's comments that not everyone who wants to downsize in a bungalow is in a wheelchair. There are many people who, for various reasons, living on their own in a big house, just want to move into a smaller property with a bit of character. And the word resist, I think, is appropriate because it does give that flexibility of district councillors when they're making a decision.
Yeah, the point I wanted to speak up on was in fact to do with specialist accommodation, and looking particularly, we mentioned in our hearing statement and at Regulation 19, was this idea of C2 use. And just looking at this as a plan that's going forward, so obviously if somebody's reading this in 5 years' time, you may have had new specialist accommodation built in C2 use. What then is taken into account if someone says, I want to convert out of that C2 use, and then you potentially lose that? And one of the things we're aware of, if we have got C2 use, as we have a couple of care homes in the village, they may well meet the current standards. They've got very good quality with a Care Quality Commission. If someone wants to come along and convert those, are there any tests there, or this might be a question for the council, what criteria
taken into account, because one doesn't want to then lose that facility, and that includes those that might be built in, say, 5 to 10 years' time and are built to the right standards, is something taken into account then to ensure that you don't lose it, perhaps because a new owner comes in, doesn't want to run that care facility, wants to change it to residential apartments, perhaps maybe more profitable to them, whatever reason, and then you go around in this circle we are looking to provide again. So I do appreciate the dynamic of taking any plot that is available now and developing it to provide it, but in the future, would you not want some criteria to assess it against so that you don't lose it later on? And then another point, which was really an adjunct to this, because we did talk about when we saw the original Regulation 19, we talked about something we know is becoming sort of popular, but of concern to some degree, residential annexes. This is another form. It's not necessarily always a granny annex. I have to say there's such a thing as a graddy annex now for the boomerang kid. What we're concerned about is that we think annex is probably a very good idea. They're another adaptable form of accommodation, often to accommodate another family member. We're not concerned about who it is. The concerns that are coming through, which are perhaps almost a development management policy, but it does come through, we note that Harlow has a policy under H7 residential annexes, is what happens if someone wants to put it at the end of the garden, and these tend to be very contentious for a number of reasons which we mentioned, I won't go into. On the other hand, most councils that seem to have policies are asking for these to be built with both a physical and a functional link, usually adjoining the property, so that if it's sold on, the next person doesn't need it. You've got the flexibility to adapt it back and integrate it into the dwelling house. Our concern is just to look perhaps to the council to provide some further information. I know we said the classic one of a supplementary planning document, which we keep mentioning because we don't know how this would be integrated later, but we thought that this was a useful provision, but something we want to be mindful of not creating what are seen as inverted commas beds in sheds in gardens, because that is contentious in private community space, but to look at a policy that dynamically manages and looks at this as a potential for something that people may want to do. It might even help sometimes for the older relative to be living with the younger relative. You have multi-generational families. It's another form of housing that we thought might be useful to take into account with some sort of policy to offer guidance on it, and that was our comment on that aspect. Thank you.
Very much. Thank you. Mr. Coleman, did you want to come back first on the point made by Mr. Goodall around how your M42 standard, if acceptable, would meet the standards without retaining potentially substandard bungalows? And then if you could address the points made by Councillor Byrne. Thank you.
Thank you, Madam. I think the answer in terms of some of the points raised, and particularly by Mr. Goodall, is that the approach of the council is a mixed approach. So it's both to provide new homes that do meet the necessary standards, and to retain, where possible and where appropriate, existing bungalows. So in tandem, the two will provide for needs. And there are opportunities to redevelop existing sites, existing bungalows, as I've set out already. So we're not saying they could not be redeveloped. Ms Byrne has highlighted that the wording is resist as opposed to must be retained. So there are opportunities for them to be redeveloped, and actually they could be replaced on site along with other development. So it's not to say that there's a blanket ban on future redevelopment of bungalow sites. So we think they provide an important part of the supply, and that together with the significant opportunities for new development across the district, that will provide for the needs, particularly if the new development meets the new standards as proposed. On the issues of Ms Byrne was regarding about annexes and the need for further policy guidance to that, we feel that there's already sufficient clarity in terms of policies in the plan and in terms of national policy. We don't think a separate policy is required. And we feel that care facilities are adequately safeguarded by the plan already, because Part F of the policy H1 says the loss of bungalows and specialist accommodation will be resisted. So we think that's already adequately addressed.
Thank you. We'll conclude the discussion there of issue 1. We'll have a break now. until 11:40, 15 minutes, and then come back to discuss issue 2 on affordable housing. Thank you. I think a couple of people have left us rather than just haven't come back a bit late. So we'll make a start. If anyone rejoins us, then fair enough. So we're going to consider now issue 2. Will policy H2 be effective in securing the delivery of sufficient affordable housing of appropriate type and size? Are the requirements for affordable housing provision from market sites justified by reference to evidence of development viability? So if we can just begin with the amount of affordable housing. So as you can see on the agenda, I'm just asking for the council to set out its evidence that the plan aims to provide more affordable housing than required. Your statement suggests 3,840 versus 2,851 needed. And I ask, does this plan target include any backlog of need as a result of under-delivery since the start of the plan period? Mr. Coleman.
Thank you, Madam. Paragraph 22 of our hearing statement suggests that the plan provides for approximately 3,840 affordable homes. This is not an exact number which the local plan is aiming to provide or that it will achieve. The figure is instead based upon applying the 40% affordable housing requirement on all allocated sites with 11 or more homes in accordance with policy H2 requirement. So in other words, it represents an ideal scenario where all relevant sites deliver 40% affordable housing. In reality, it is unlikely that the council will be able to secure 40% on all of those sites. The 40% affordable housing requirement, therefore, set out under policy H2 provides for flexibility within the plan to achieve the quantum of affordable housing required. Therefore, if some sites do not come forward or cannot for reasons of viability or other considerations, if they cannot provide for 40%, the overall need for the district will still be sufficiently addressed. In terms of the backlog, the planned target for 2,851 new affordable homes between 2016 and 2033 is based on the latest SHMAR update from 2017. That work identifies the unmet need for affordable housing at a base date of 2016 and accounts therefore for affordable housing completions that took place between 2011 and 2016. The reference for you for that is EB 408 and it's paragraphs 3.61 and 3.62. Consequently, all the needs arising over the remaining plan period from 2016 onwards have been identified. Therefore, there is no requirement to include any backlog of need. albeit that obviously time has passed since the SHMA update was produced in 2017, and therefore there is potential for further shortfall in the years since then in terms of provision. But that links to the earlier point about not over-providing, because it's quite likely that we will have slightly under-provided in recent years. And with reference to the latest AMR, in 2017-18, 89 affordable housing units were delivered in the district. And that's paragraph 1.130 of EB 1708M.
Before we take comments around the table, I don't know if we've had this discussion before or not. I wonder whether is the actual targets for how many the plan does aim to provide, the 2851 for the period you gave, is that actually reflected in policy in the same way that the overall housing requirement is? And if it isn't, should it be?
Yeah, I don't think it is.
Do you think it should be? No.
We think it probably should be, so we'll look to address that through a proposed modification.
Any comments on the amount that the plan aims to deliver, Mr. Belton?
Yeah, it's just a minor point picking up from what we've said in our statements. Looking at the delivery of affordable housing from the start of the plan period, there obviously has been a very significant shortfall, and that's led to a backlog. If you take the need for 3,100 affordable dwellings over the full plan period, you'd be looking at about 140 affordable units being provided every year. And we know that that hasn't been achieved so far. And once you factor in that backlog, that annual requirement, if you just spread it over the remaining years of the plan period from 2018, would require 191 affordable housing units to be delivered every year. Now, to achieve 141 affordable dwellings with a 40% affordable housing policy, you'd need to have planning permission every year for 478 dwellings on sites that qualify for affordable housing. And we have concerns about that because, as we spoke about in Matter 6, what the Council are proposing is the stepped housing trajectory. And we think you need to go back to the figures set out in that stepped trajectory to answer the question as to whether this policy will deliver sufficient affordable housing over the plan period. And I say that because the Council have said that this stepped trajectory provides realistic and achievable housing numbers. And we know that that step trajectory is saying that up to 2023, the maximum number of units that we should assume is 425 dwellings. Now, if you assume that each and every one of those 425 dwellings will provide 40% affordable housing, which obviously they won't, there's still going to be less affordable housing provided year on year. And as a result, what the Council, I think, are proposing is a bit of a hockey stick type strategy whereby the plan as a whole will only meet the affordable housing requirement by big uplifts towards the end of the plan period. We've set out to you already concerns we have about delivery assumptions on some of the larger sites, the ability of them to deliver 40% affordable housing. And we think relying on this sort of big uplift towards the end of the plan period is very risky. We don't think it's positively prepared, and we don't think it's justified. And given there's been such a shortfall in affordable housing delivery in effectively the first half of the plan period, we really think the plan should be prioritising the early delivery of affordable housing rather than trying to put it to the back end of the plan. And to do that, you need sites that can deliver affordable housing and now and in the early part of what will be the plan period post-adoption.
Mr. Butcher.
Thank you. Can I just clarify the discussion about the modification just now? Is that to include the 2851 figure as part of the policy or as referenced into the justification?
It was a question I asked that I'm happy to take comments on. When you look at the number of houses to be provided in total, that's put in the actual wording of the policy, whereas the affordable housing isn't. I wondered, it just occurred to me whether it should be to reflect how many the plan overall is aiming to deliver. So it was a question really, rather than the council said they think it should be, but you may have a different view.
If I could, sorry, just to clarify, it is actually set out in paragraph 3.9, so apologies. It's in the supporting text as opposed to the policy, but the number is there.
Yeah. And do you think that's sufficient, or do you think it needs to be in the policy? Is it just a question?
Well, my view is it's sufficient to be as it is, not to be in the policy itself.
So on that basis, Mr. Butcher, your point.
So I think our view would be that the policy should state the figure, but the sort of prefix of as a minimum. I mean, what we note is that in terms of the level of need at 2,851, based on the council's calculation using the sort of allocations total, and then times that by 40%, that would result in approximately 3,800 and odd affordable homes, which we think is a significant excess of around about 1,000 homes. And the point is this excludes small sites, and it also excludes office to residential conversions, which the council are concerned don't provide any affordable housing. But if you follow the council's same calculation at 30% related to the council's allocations, that provides approximately 2,900 homes, which is still in excess of 49. And this supply also excludes rural exceptions and potential windfall sites. So we consider that at 30% the council's need will be met. And we sort of question why the 40% figure has been used, and perhaps why not a figure of 35%, where that will also result in some surplus to sort of adhere some of the council's concerns.
Thank you, Mr. Butcher. I think we're sort of moving on to the second bullet point now in terms of the council's requirements for development, which is fine by me. That's next on the agenda. Is there anything people haven't been able to say in relation to the overall amount? If not, well, then we'll move on to the housing requirements. So can I ask the council to move on to that point? And if you explain the evidence which justifies the requirements of 11 plus units to provide 40% affordable housing, as opposed to perhaps any other figure. And my second bullet point as well asks specifically about whether there are circumstances that might justify lowering the requirement to 30% on the east of Harlow site. Since this agenda, I've read in a little bit more detail the Garden Town work that you produced, and so I'd extend that question, I suppose, to the other Garden Town sites, particularly Water Lane, in light of the viability work that you've done for that. So maybe if you can sort of talk about the whole plan level justification, and also the Garden Towns as well, please. Thank you.
Thank you, Madam. This does overlap somewhat with the earlier, I think it was Matter 5 session. You recall where we had Dixon Selwell Viability Consultants here. I should also say from the outset that we will have our viability consultant for the Garden Town work here tomorrow.
Okay, yep.
For the infrastructure session.
Okay.
The evidence itself that underpins the requirement comes from primarily from the Stage 2 Update Assessment of Viability. It's a very long title. Essentially, the Local Plan Viability Study from November 2017, and that's EB 301. As you heard previously, this tested in some detail the policy requirements in the plan and concluded that the requirement for 40% affordable housing on sites of 11 or more units is viable at a whole plan level. And that is set out at paragraph 27 of page 6. I think that's the executive summary of that report. In terms of the more recent work you've just referred to that the Council has published, that's the Garden Town Viability Study, and that's EB 1417. Obviously only covers sites in the Garden Town itself. That has assessed the key Garden Town communities independently based on the Garden Town IDP, and therefore provides a more up-to-date and detailed assessment of viability on those sites to supplement the work I've just referred to. The work has found challenges in terms of viability on particularly Water Lane area site and east of Harlow site, but importantly concludes, I'm just going to quote for you, if I may, this is paragraph 12.138 of that study. The councils can be confident that the sites are deliverable. However, on some of the sites, that it may be necessary to discuss the details around viability. As shown, flexibility around the timings of infrastructure payments and the mix of affordable housing can have a significant impact and improve viability notably. Such an approach would allow a fully policy-compliant scheme to be delivered, albeit with some compromise over timing. So in light of that conclusion and the detailed assessment and analysis set out in the report, the Council does not consider that it is justified or necessary to lower the requirement in policy on the east of Harlow site or indeed on the Water Lane area site. Policy H2, parts D and E, make provision for the process that will be followed should a reduction in the level of affordable housing on development sites be sought, where the viability of an individual development and therefore its delivery may be in doubt. And I should also refer you to Homework Note 12 produced by the Council, and a number of amendments set out within that document that provide further clarification on how the Council, under which circumstances the Council will consider the viability of individual schemes, and therefore how that would work in practice is much clearer. Includes the submission of a delivery statement by the applicant to show whether or not a scheme can be viably delivered, and if not, why not, based on the viability work that's been undertaken by the Council. The other thing, just to add on the Garden Town Viability Study, as I said, the study does acknowledge that there are challenges on those two sites, but does also set out that that's not unusual for sites of that scale and complexity. And as we know, the schemes will be subject to the production of a strategic master plan, and further work over time will obviously evolve the picture considerably. So the Council acknowledges, therefore, that there may be opportunities or circumstances where further viability work will need to take place on those sites at the application stage.
Before I just turn to the others around the table, just from my sort of initial look at that study, the challenges on the Harlow part of the site would obviously seem a lot less, by quite considerable margin. do you think there are any risks, or are you concerned in any way about the sort of the difference in the viability challenges presented on either side of the border in relation to that particular allocation?
In short, no, because essentially it's one scheme across two different local authority areas. It will be one master plan, and it will be subject to duplicate planning applications submitted to the two councils. So I don't think it's correct to consider the viability separately in that manner, albeit there are practical issues in terms of how the application will be determined when the time comes. But I also think there's a number of unknown elements at this point in time which may result in changes. So we've talked previously about the potential for instance, the secondary school to be located potentially in Harlow as opposed to in Epping. And the plans at the moment assume that the secondary school will be in the Epping Forest District. So changes like that will affect viability. And at the moment, until the master planning work is further progressed, it's difficult to know the extent of those challenges and the impacts they'll have on viability.
Thank you. Anybody else on the council's requirements for 40% on 11 plus? Okay, thank you. So the next question then on the agenda, is it justified to apply the requirements for affordable housing to all types of housing, including that falling within use class C2? Yep, I think I had a typo there, but I've corrected it on the agenda. Most people recognise my typo and didn't point it out and just answer the question properly, so thank you for that. Does the MPPF or PPG indicate that some developments, including purpose-built accommodation for the elderly, should not be required to provide affordable housing? The council's position was that there is nothing seeking to prevent contributions from C2. Does anyone have a different view to the council, or wish to raise any comment in this regard?
Madam, sorry, if I could just clarify that the council's approach is to apply the requirements for affordable housing to all types of housing, including that falling within self-contained use class C2 floor space, as opposed to all C2 floor space. So there is a subtle difference.
Okay, and then a fairly simple point on the end. If I conclude that it is justified to repeat the build standards expected in policy H1, in policy H2 part A, should part A be specific about the standard expected? And that's the same question as in the previous policy. If you're going to require a specific standard, make it clear what standard you're requiring. It's exactly the same principle as far as I was concerned. So no comments? Okay, so turning now to the mix of affordable housing. Council's proposing a number of amendments to this policy, which perhaps I could ask you to take us through. So one to Part A, to clarify that the clause concerns the appropriate tenure mix. To paragraph 3.16, to clarify how developers should determine the appropriate type and tenure mix of affordable housing required. And then finally to Part E, to ensure that it doesn't suggest that a very specific tenure mix is set out in the policy. Perhaps if you could explain the alterations you're proposing, and then we can discuss Part C.
Okay, thank you, Madam. So as you rightly say, the first modification is to Part A, and is, I think, self-explanatory in terms of explaining the tenure mix of affordable homes, including the tenure. The second modification is to paragraph 3.16 and inserts the words, applicants are therefore advised to contact the Council's housing service for the most up-to-date information with respect to affordable housing needs. Again, is aimed to provide further clarification. In terms of, is it necessary to justify for Part C to expect the mix of affordable housing to reflect the mix of market housing? Would you like me to? Yeah. So Council considers it is necessary and justified for Policy H2 Part C to expect the mix of affordable housing to reflect the mix of market housing. However, the first section of Part C sets out the overall principle of the policy requirement, i.e. that the mix of affordable housing on site will be determined on a site-by-site basis, reflecting the overall needs of the local area and specific characteristics of the individual site. The second part of Part C requires the affordable housing mix to reflect the mix of market housing in order to establish tenure-blind developments and integration of affordable units within the wider market units wherever possible. So to clarify, the policy does not explicitly require the mix of affordable housing to precisely mirror the mix of market housing, reflecting the fact that actual needs may differ from site to site. But the intention is to ensure that there is not a major separation in terms of the types of units that come forward for affordable versus the types of units that come forward for market housing. And there is a modification finally to Part E to clarify where it has been demonstrated to the Council's satisfaction that the provision of affordable housing in accordance with the above levels, and to insert the words, and the preferred tenure mix as indicated by the most up-to-date evidence, and then carrying on, would render the scheme unviable. The Council will determine the approach to be taken to achieving viability where appropriate, having regard to the following available option.
Thank you. Any comments on the mix of affordable housing, either in relation to those specific points or otherwise? Mr. Butcher.
Yeah, it's just a sort of simple observation, really. The potential for the sort of policy objectives to conflict if you're relating it to sort of market housing. Figure 76 of the SHMAR 215 EB 405 suggests that in terms of market housing, the need is for about 76% to be for 3-bed plus. In relation to affordable housing, figure 22 of the update, EB 408, suggests that in the intermediate, it's 62% for 2 units or less, and in relation to affordable rent, it's for 57% for 2 units or less. So we just sort of see the potential conflict which could result in market homes which are too small, and affordable housings which could be provided to be too large. And so we just sort of see that as a potential conflict.
Which figures did you refer to, sorry, for the affordable housing?
Figure 22 of the update, EB 408.
Thank you. Do you have any response to that, Mr. Coleman? 'Cause and on whether it is the sort of mix of the mix of sizes that is actually relevant? And if you do, then perhaps you can comment on the figures that Mr. Butcher referred to, or is it more a question of the design to ensure that it appears tenure blind? If it's the latter, is the mix the appropriate way of achieving that?
It is both, Madam. But I think, as I've set out, we don't anticipate that the mix will be exactly the same for affordable as it will for market. We recognise that the primary consideration needs to be the need and addressing the need. But if you like, as a secondary consideration, we would like the mix to be closely related for affordable as to market. So it's a combination of the two, but the primary consideration is need. Just to add, we think it's important because it will help to integrate the types of housing into the design of the development. So it's not just about the design itself and incorporating different tenures within and throughout the development. It is also about the nature of the units coming forward and the size of those units coming forward as well, which is important so as not to differentiate between the different tenures.
I think it's just important to note that when you are starting to discuss the combination of both housing mix and tenure mix, which I think is the direction that the modifications are heading in, both of those things, in particular the current format of need for intermediate tenures, will reflect what's been delivered at the moment, and principally that's a function of housing that people can't currently access. So what you will find going forward is that products such as starter homes, low-cost housing, which aren't well covered by the plan, if they're positively supported, they will meet needs that aren't currently being met. And actually, that's an element of the discussion that doesn't seem to be picked up by these modifications, because the plan doesn't really clearly indicate those in its evidence. And I'm not sure that the modifications will really address that. You're still somewhere between a prescriptive requirement and a plan that doesn't meet full needs and doesn't really contain the opportunities to meet those needs in full.
Mr. Coleman.
Possibly slightly confused by Mr. Goodall's point, but I think the SHMAR does set out the needs for different types of tenure and different mixes over the plan period. So I don't think there's an issue about the evidence and what the needs are. And I think what we are seeking to do is to blend and to produce the most appropriate mix, and in terms of size and tenure, that will allow for needs to be met whilst ensuring integration of the developments, integration of affordable units within the development.
Thank you. Any other points on policy H2? Okay, so we'll turn now to policy H3, issue 3. So policy H3 concerns rural exception sites. Now, again, in response to my questions, there's a number of modifications proposed to this policy. A couple of them, the second two, are quite straightforward, and I assume they're not going to be controversial. So just to deal with those first, a modification to Part A2 to ensure that terminology is used consistently, basically referring to the existing settlement. And also to Part F, just to correct a cross-reference concerning the provision of viability appraisals, correcting it to Part E rather than Part D. Now, does anyone have any comments on those, or can we move on to the main point? I was wondering if the council could just be clear, just clarify for me the intended location of rural exception sites. You've proposed some modifications to Part A and to paragraphs 3.17 and 3.18. If you could just explain those. And I just wonder, is it the case that rural exception sites could potentially be permitted in any settlement, including larger settlements, if the need could be justified? Thank you.
Thank you, Madam. So the council proposed modifications in response to your question on matter 11, issue 3, question 1. And we considered that policy H3 would benefit from further clarification in relation to the location of rural exception sites and windfall developments. So the modifications are set out on pages 18 to 19, paragraphs 38 to 41 of the hearing statement. To try and succinctly clarify the purpose of those amendments and for the application of rural exception policy, the policy seeks to provide clarity in terms of the types of settlements and locations that are capable of accommodating rural exception schemes. This is essentially where there are no allocations present in the settlement that are capable of providing for affordable housing. So that does mean that it's not the case that rural exception schemes could come forward adjacent to any settlement in the district. It's recognising that some of the smaller settlements do not have specific affordable housing provision coming forward within the plan period, and therefore would benefit potentially from rural exception schemes.
Thank you. Any comments in relation to that matter or otherwise in relation to H3? Thank you. Turning finally to H4, traveller site development.
We'll be joined by Ms. Karen Moore, also a consultant to the council.
Okay, thank you. Okay, so the question here is the size limit for non-allocated traveller sites imposed by policy H4 justified? Is the policy otherwise justified, effective and consistent with national policy? Now, the council is considering modifying Part C, I think, to retain the 5 to 10 pitch limit on traveller sites, but to remove the 0.5 hectare site size limit. Perhaps if, as you're here, if you can just explain the rationale behind that, and then I'll take any comments if needs be. Thank you.
Yes, Madam. The rationale behind changing the site size is that having looked again in response to your question, it was in response to your question that with regard to whether or not we actually required a pitch size and a pitch number. And we've considered that, and we think it's more appropriate to include a pitch number, and that this will future-proof the plan in the event that size requirements for pitches rise in the future as a result perhaps of the use of larger vehicles or caravans or mobile homes, but also in terms of enabling a more equitable treatment in respect of plot size for need. So, for example, if a particular family requires a paddock and so on, there's no reason why we should prevent them having that space. So that was the purpose of the actual modification. Would you like me to address the pitch limit, the 5 to 10 pitch limit? Yes. Okay. So that limit is justified by the evidence that we set out in our matter statement 11, the hearing statement at paragraph 47, and I'll just very briefly revisit that. That is that, firstly, we had a clear response from respondents to the 2012 consultation in relation to a preference for smaller sites for travellers' provision. We also have a preference as a council in our strategy to match the pattern of existing sites in the district, which by and large are smaller sites. Thirdly, the majority of that need, the need arising over the plan period is from existing sites in the district. In addition, we have experience as a council that smaller sites tend to establish a more harmonious relationship between settled and travelling communities. We also, as a council, have the objective of seeking to avoid further over-concentration of sites in certain areas in the district. I expect you will recall this from previous hearings. And our approach was supported by the findings of the sustainability appraisal.
Any comments? Thank you. And again, just so everybody's aware, to point out a cross-reference in Part C is wrong. Should be SP5 rather than SP4. Thank you. Anything else that anyone hasn't had the opportunity to raise so far? Mr. Stebbing.
Back to the first matter of this morning, if I may. You indicated that you will go away and think about the 5-year housing supply position. How will you announce that to examination participants?
In a similar way to everything else. So what I'll need to do is the matters that we haven't been clear where modifications are required already, I'll need to provide some post-hearing advice, which I'll do after the hearings finish on the 11th of June. And if I agree with the council's position, then essentially it will be notified in there because a modification may be required, but probably be notified in there or in my report, I suppose, at the end of the day. As it's come up, it's probably something I would give some indication of in that post-hearing advice. Okay, so back at 2 o'clock for any of you who are remaining. Thank you very much. Thanks for your contributions.